friends, welcome to the online channel of the KPS College Bhavnagar. In today's virtual class, we are going to discuss joint stock companies and its various types from unit number 1 of business communication subjects. This video is prepared for all the students of Maharaja Krishna Kumar Singh Ji Bhavnagar University. So, dear friends, before moving towards various types of joint stock companies, let us try to understand what is joint stock company. A joint stock company is a voluntary association of individuals for profit, having a capital divided into transferable shares, the ownership of which is the condition of membership. So, in other words, you can say a joint stock company is a business entity in which shares of the company's stock can be bought and sold by the shareholders. Each shareholder owns company stock in proportion, and that is evidenced by their shares. That is what we call certificate of ownership. Shareholders are able to transfer their shares to others without any effect to the continued existence of the company. So, when a seller sells some shares to the buyer, there is no effect to the company's existence. In modern day corporate law, the existence of joint stock company is often synonymous with incorporation. So that is what we know as possession of legal personality separate from shareholders, and it is also synonymous of limited liability. That is, shareholders are liable for the company's debts only to the value of the money they have invested in the company. Therefore, joint stock companies are commonly known as corporations or limited companies as well. That is what we nowadays understand by the term of the company. Therefore, joint stock companies are commonly known as corporations or limited companies. Some jurisdictions still provide the possibility of registering joint stock companies without limited liability. Countries like United Kingdom and some other, they have adopted its model of company law, and that's why they are known as unlimited companies. However, in the United States, they are simply known as joint stock companies. Even in India, we know such kind of companies as joint stock companies. So this is what we have, this is how we understood the definition of joint stock company. Dear friends, now let us turn towards various types of joint stock companies. I hope you understand the definition of joint stock companies. So it would help you to understand various types of joint stock companies in the videos ahead. Now, let us try to understand what are various types of joint stock companies are. So, companies can be classified into 3 different types. Try to remember the 3 different types. Number 1, on the basis of incorporation or registration. Number 2, on the basis of liability. And number 3, on the basis of ownership. So let us try to consider the first one, that is on the basis of incorporation or registration. If we classify further these kind of companies, number 1 would be a chartered company. Number 2, statutory company. Number 3, registered company and foreign companies. These are all types of companies which are covered under the category of incorporation or on the basis of registration. So let us try to understand what charter company is. Charter companies are the companies which were formed during the 17th and 18th century by the kings and emperors by passing special charter known as royal charter. So the rules and regulations for the working and governing of the companies are clearly mentioned in that royal charters. But nowadays, these kind of charter companies are not formed. And these companies are not especially found in India anywhere. But if we think about the examples, in the past there was East India Company, Bank of England, etc., which are considered under this kind of company. Number 2, that is statutory company. Statutory companies are formed by passing a special act, either by state legislative or by parliament. Generally, statutory companies are formed to run public utility concerns like railways, waterworks, gas works, electricity, etc. The rules and regulations for the working and governing of the company are clearly mentioned in the special act that is known as statute. If we think about the examples in India, the Life Insurance Corporation, Air India, Unit Trust of India, the Reserve Bank of India, as well as Import-Export Corporation of India are some of the examples of. Number 3, that is registered companies. A company registered under the Companies Act is known as registered companies. The rules and regulations regarding its formation, working and continuity of the company are clearly mentioned in the relevant Company Act of the particular company. In India, all the companies except chartered companies and statutory companies are the registered companies. So you can consider all those companies as an example or as example of registered companies. The registered company is owned by the shareholders and managed by the elected representatives of shareholders, which we know them as board of directors. A registered company may be formed on one of the following companies. So we can make a different classification or different types of registered companies. Number 1 is a company limited by shares. Number 2, a company limited by guarantee. Number 3, private company. Number 4, public limited company. And number 5, that is unlimited liability company. For example, you may say Hindustan Lever and Procter & Gamble, that is P&G, are some of the examples of registered companies in India. Number 4 is foreign company under the category of incorporation or registered companies. So let us talk about foreign companies. Foreign company is a company which is registered outside India under the Companies Act of that respective country, having its branch for business in India. So basically the company was established outside India, but they are having some of the branches inside the country, that is India. The foreign company has to submit the following documents with the registrar of the companies within 30 days of establishing its business in India. So they are required to submit the following documents. I speak a certified copy of Memorandum of Association and Article of Association of the company translated in English, that is international language. Number 2, the complete address of registered office of the company. Number 3, a list of directors and secretary of the company. And number 4, the complete address of its head office in India. So these are the 4 types of companies which can be established on the basis of incorporation or registered companies. Now let us talk about the second type of our main point, that is on the basis of liability. So let us talk about the company limited by shares first. The company where the liability of shareholders of the company is limited up to the extent of the face value of the shares held by every shareholder is called company limited by shares. The shareholders are not responsible for the liabilities of the companies and they cannot be called upon to pay even a single paisa more than that of the unpaid amount of the shares. These type of companies are very popular in India. We see many of the companies which are limited companies all the companies that have a tag limited or private limited are under this category. The principles of limited liabilities attract investors to invest in the shares of the company. So number one was company limited by shares. Let us talk about the second one, that is company limited by guarantee. As the name suggests, the liability of members of the company is limited up to a specific amount guaranteed by the company. The purpose of such guarantee is to enable the company to have funds to meet its liability in the time of winding up. The important features of such companies include: number one, each member promises to pay a fixed amount in the event of wind up. So when the company winds up, a particular amount must be given to the particular holder. This amount, number two, is known as guarantee amount. Number three, the amount of guarantee is laid down in the memorandum of association. So this amount is fixed. Number four, the amount of guarantee is paid only in the case of winding up of the company. Number five, such a company may or may not have a share capital. And number six, the capital may be raised through entrance fees, membership fees, donations, etc. Such companies may be a public company or private company and can be converted into a company with liability limited by shares by passing a special resolution. So examples of such companies include the trade unions, charitable hospitals, educational institutes, and many others, which are established by these kind of laws. Number three, companies with unlimited liabilities. A company which is registered without the provision that the liability of its member is limited is an unlimited liability company. Liability of members of such company is unlimited, like the sole trader of sole trading concern and the partners of partnership firm. It means in the case of winding up of a company, the private property of the members can be taken over by the creditors for the recovery of their dues, that is debts. Such companies are not much popular in India. Now let us take into account the third type, that is called on the basis of ownership. The third classification of types of companies is under on the basis of ownership. On the basis of ownership, the companies can be divided into 7 different types. Number 1, private company. Number 2, public company. Number 3, deemed public company. Number 4, government company. Number 5, multinational company. Number 6, holding company. And number 7, subsidiary company. Let us talk about the private companies first. A private company is a company which by its articles of association restricts the following things. Number 1 is it has the right to transfer shares. Number 2, it limits the number of its members to only 50, that is 50 members. And last one, that prohibits an invitation to public or to subscribe its shares or debentures. So in other words, we can say a private company is an incorporated body registered under the Companies Act with 3 important restrictive provisions in its article of association, which contains rules and regulations for the internal management of the company. A private company requires minimum 2 members and 2 directors. A private company has to file the following documents with the registrar of the companies. Number 1, the memorandum of association, which contains the information about the name, address, capital, and about the object of the company for which it is formed. It is to signed by at least 2 persons. The words private limited, or we call private limited companies, must be added with the name of the companies. Number 2, articles of association. The articles contain the rules and regulations for the internal management of the company. And number 3, statutory declaration, which is that is all the legal requirements have been compiled with, and after satisfying the registrar issued he or she issued a certificate of incorporation which qualifies the company to start its business. There are some restrictions also which are imposed on the private companies. The restriction number 1, a private limited company must include the word private limited with its name. Number 2, a private limited company must have its own article of association. Number 3, the shares of private company are not transferable. Restriction number 4, a private company cannot invite public to subscribe its shares or debentures. Number 5, the maximum number of members in a private company is restricted to 50, as we have discussed earlier. Every year, private company must file 3 copies of balance sheet and profit and loss account together with auditor's report to the registrar of the company. And number 7, a member of private company can appoint only one proxy. So these are the things about private companies. Let us talk about a public company now. According to the Indian Companies Act 1956, it defines public company as a public company is a company which is not private company and which does not have any restriction of a private company. A public company requires minimum 7 members and there is no upper limit for the maximum number of members. It requires at least 3 directors and the directors retire by rotation. Public companies has to file the documents like memorandum of association, articles of association and prospectus with the registrar of the company, same as private company. Public company can adopt table A in place of articles of association and can file statements in lieu of prospectus in place of prospectus if requires. Public company has the following features. So these are the features we should understand to understand the difference between public and a private company. So let us try to understand some features. Number 1, a public company collects capital from general public by way of issuing shares and debentures. Number 2, the shares of public company are freely transferable. Number 3, the liability of the members of public limited company is limited up to the extent of face value of the shares purchased by them. Number 4, public company must collect minimum subscription and must obtain trading certificate, that is certificate of commencement of business to start the business. Number 5, the public company must start its business within 1 year of getting incorporation certificates. Otherwise, it will be wound up by the court and it will not be considered anymore. Number 6, it is also compulsory for a public company to hold statutory meeting within 6 months of obtaining a trading certificate. So these are the features which defines a public company. Number 3 is deemed company or deemed public company. As per the section 43A of Companies Amendment Act 1960, a company which is originally registered as private company but is converted into a public company due to operations of law or due to any of the following reasons is termed as deemed public company. There are a few things which you should keep in mind about deemed public company. Number 1 is if 25% or more paid up share capital of a private company is held by a public company. Number 2, if a private company holds 25% or more paid up capital is held by a public company. And number 3, if a private company holds 25% or more paid up capital of a public company. So on these 3 conditions, a deemed public company is established. Let us talk about number 4, that is government company. A government company is one in which 51% or more paid up capital of the company is taken over, either by state government or by central government or even by both. The government companies are incorporated under Indian Companies Act in India. It may be noted that in a government company, government is the major shareholder and the majority of directors are appointed by the government itself. So these are the things you should keep in mind about government company. Number 5 is multinational company. A multinational company is the company which is registered in one country but operated its business in multiple countries. So basically a company is established in a particular country, but it is running the business in many other countries, which we call multinational company. They have huge investment and huge profit, obviously, because the turnover is done in many currencies. They build up business empire in many countries, and so they create employment opportunities, and these companies recruit and promote managerial persons on merits. So there is no direct dominance of government or any other laws of the government. Number 6 is holding company. A company which holds 50% or more paid up capital of another company, that is subsidiary companies, is known as the holding company. Holding company controls and manages the entire affairs of subsidiary company. So let us understand number 7, that is subsidiary company. So you will understand holding company as well as subsidiary company. Number 7 is the subsidiary company. The company of which 50% or more paid up capital over by another company, that is holding company, is known as subsidiary company. The management of subsidiary company is controlled by the holding company, but subsidiary company does not lose its identity, and that is what we call subsidiary company. So here I conclude with various types of companies, especially the joint stock companies, as a part of your syllabus. We will definitely come up with more videos for you in near future. Thank you for watching this video. Have a nice day. Have a great time. Thank you.